Like, share, and comment now to unlock exclusive content. Don't miss out on the action.
Hello everyone. I'm Eric, the workplace safety guy. There is something happening right now on farms across America that most people have never heard about, and the silence around it has already cost lives. Every single day, more than 2 million agricultural workers step into fields, greenhouses, forests, and nurseries across the United States. They wake up before sunrise, put on their clothes, eat breakfast with their families, and drive out to do the work that feeds this entire country. But what many of them don't know, and what many of their employers choose not to explain, is that the chemicals being sprayed in those fields, on those crops, between those rows where they bend and pick and walk for hours, are some of the most dangerous substances legally used in the American workplace. These are not mild irritants. We are talking about compounds originally derived from nerve agents developed during World War II. We are talking about organophosphates that can cause muscle spasms, seizures, and permanent neurological damage. We are talking about chemicals that have been linked to cancer, Parkinson's disease, and developmental disorders in children born near treated fields. And we are talking about a legal framework, a set of federal regulations, that was designed specifically to protect these workers, and that is still, in too many cases, being ignored. The rules exist. The protections are written down, codified into law, backed by federal enforcement authority. The Worker Protection Standard, regulated under 40 CFR Part 170 by the Environmental Protection Agency, and the overlapping standards enforced by the Occupational Safety and Health Administration, these suggestions. They are legal obligations. And yet, a 2024 report concluded that farm workers face a level of occupational risk unrivaled by most workers. So the question is not whether the laws exist. The question is whether anyone is actually following them, and whether you know what those laws actually say. Because if you are an agricultural worker, a supervisor, a farm owner, or simply someone who cares about the people who grow your food, what you're about to hear could change everything you thought you knew. Stay with us. Because what comes next is not theory. It is law. It is science. And for some people, it was already too late before they ever heard these words. To understand the full picture, you have to start at the beginning, with the law itself. The Worker Protection Standard, commonly known as the WPS, is a federal regulation issued by the U.S. Environmental Protection Agency under the authority of the Federal Insecticide, Fungicide, and Rodenticide Act, known as FIFRA. The WPS is codified at 40 CFR Part 170, and it covers any pesticide that carries an agricultural use requirements section on its label. That means virtually every commercial pesticide used on farms, in greenhouses, nurseries, and forests across the country falls under this standard. The WPS was originally created in 1992 and was significantly revised in 2015, with the revised rules taking full effect by 2017. In September 2024, the EPA finalized additional updates, particularly to the application exclusion zone rules, with those changes taking effect on December 3, 2024. These updates were not minor tweaks. They were a restoration of protections that had been weakened in 2020, and they reflect years of advocacy from farm worker health organizations, epidemiologists, and legal advocates who watched workers get sick while regulatory gaps remained open. So what exactly does the WPS require? Let's go through the main pillars, because each one is a legal obligation, not an optional best practice. The first and most foundational requirement is mandatory annual training. Under the WPS, every employer must ensure that all agricultural workers and pesticide handlers receive pesticide safety training before they are exposed to pesticides, and then again every 12 months without exception. This isn't a general orientation or a brief handout. The EPA specifies exactly what that training must cover, how pesticide exposure occurs, what the symptoms of poisoning look like, how to properly use personal protective equipment, what to do in an emergency, and how to read safety information posted at the workplace. The training must be conducted by a qualified trainer using EPA-approved materials, and employers must maintain records proving that each worker completed it. The underlying principle is simple but profound. You cannot protect yourself from a danger you do not know exists. The second major pillar is the control of access to treated areas through what the WPS calls the Restricted Entry Interval, or REI. After pesticides are applied to an agricultural area, that area is legally off-limits to workers for a specific period of time that is defined on the pesticide label itself. The REI exists because pesticide residues remain active and dangerous on plant surfaces, in the soil, and in the air long after the application equipment has left. Employers are legally required to enforce these intervals through signage, verbal communication, and physical barriers if necessary. No worker may be allowed or directed to enter a treated area before the REI has expired. Violation of this rule is not a procedural misstep. It is a federal regulatory violation with potential fines and license consequences. The third requirement, and one of the most technically specific, is the Application Exclusion Zone, or AEZ. This rule, which was significantly strengthened by the December 2024 update, establishes a mandatory buffer zone around pesticide application equipment during outdoor applications. The AEZ extends 100 feet from the equipment for high-drift applications, such as aerial spraying or air blast sprayers, and 25 feet for low-drift applications. What makes this rule particularly important is that the AEZ moves with the equipment. It is not a static boundary drawn around a field. It travels, and it does not stop at the edge of the employer's property. The 2024 rule explicitly restored the requirement that the AEZ applies even when it extends beyond the farm's boundaries, into neighboring roads, schoolyards, or residential areas. If anyone enters the AEZ during an application, the handler must immediately stop spraying. The application cannot resume until those people have left the zone. This brings us to the fourth pillar, personal protective equipment. The WPS requires employers to provide, at no cost to the worker, all PPE specified on the pesticide label. This can include chemical-resistant gloves, protective clothing, safety eyewear, and when required, respirators. But providing the equipment is only half of the legal obligation. The WPS also requires employers to ensure that the equipment is in good working condition, that workers are trained on how to use it correctly, and that contaminated PP is not worn home. For respirators specifically, the WPS cross-references OSHA's own standard at 29 CFR 1910-134, which requires employers to provide medical evaluations, annual fit tests, and specific respirator training before any worker uses respiratory protection. These are not parallel suggestions. They are intersecting legal requirements that together form a comprehensive protection system. The fifth requirement is decontamination. Under the WPS, employers must provide clean water, soap, and single-use towels at accessible locations near work areas throughout the workday. These decontamination stations must be available so that workers can wash immediately if they come into contact with pesticides. The importance of this requirement cannot be overstated. Many pesticides penetrate the skin within minutes of contact. Early washing is one of the most effective ways to reduce absorption and prevent acute poisoning. Providing these supplies is not optional, and making them difficult to access, through distance, language, or cultural intimidation, is a violation of the standard. The sixth pillar is the right to information. Employers are required to maintain and display pesticide application records at a central location accessible to all workers during normal working hours. These records must include the name of the pesticide product used, the location and time of application, the REI, and contact information for emergency medical services. Workers have the legal right to request this information, and employers are prohibited from retaliating against any worker who asks. This right to know is central to the architecture of the WPS, because informed workers are empowered workers, and that empowerment is precisely what the standard was designed to create. Now, alongside the WPS, OSHA also plays a critical role. Farm worker pesticide exposure does not fall entirely under OSHA jurisdiction the way it does for most workers. The gap has been the subject of ongoing legal debate, but OSHA's hazard communication standard at 29 CFR 1910-1200 requires that all chemical hazards in the workplace be communicated through proper labeling and safety data sheets, known as SDS. The SDS for any pesticide must be available to workers on request and must include information on chemical properties, health hazards, first aid measures, and emergency response. OSHA's respiratory protection standard at 29 CFR 1910-134, as mentioned, applies wherever respirators are used. And OSHA's General Duty Clause, Section 5A1 of the Occupational Safety and Health Act, creates a broad legal obligation for every employer to maintain a workplace free from recognized hazards that are causing or likely to cause death or serious physical harm, even when no specific standard directly addresses the situation. Together, the WPS and OSHA create a legal web of protections that, when followed, would meaningfully reduce pesticide poisoning in America's agricultural workforce. The tragedy is not the absence of rules. The tragedy is the gap between what the rules say and what happens in the fields. And that gap has a human face. Which brings us to part 2. On a hot day in late July 2019, a group of migrant farm workers from South Texas was working inside a cornfield in DeWitt County, Illinois. They were moving through the rows, doing the labor that is invisible to most consumers, the kind of work that happens between the planting and the harvest, the work that requires human hands moving through green stalks for hours at a time. There were teenagers in that crew. There was a pregnant woman. And then, without warning, a crop duster appeared overhead. The aircraft swept over the field and released a spray of pesticides directly onto the workers below. According to a lawsuit filed on December 2, 2020 by Legal Aid Chicago, Texas Rio Grande Legal Aid, and the Environmental Law and Policy Center on behalf of the workers, the crew panicked. They ran from the field with their clothes soaked in chemicals. Their eyes burned. Their throats burned. Some of them had trouble breathing. 2 weeks later, it happened again, in the same field, from the same type of aircraft, twice within 30 minutes. The symptoms that followed were not minor. The lawsuit documented shortness of breath, blurred vision, painful skin and eye irritation, vomiting, headaches, extreme fatigue, and dizziness. 5 children who later came into contact with the sprayed workers also suffered health consequences. And according to the suit, these health problems were ongoing, not resolved in a day or a week, but persistent, chronic, and life-altering. Now let's look at what should have happened under the WPS and what clearly did not. The application exclusion zone requirements, the legal obligation that existed in 2019 under the 2015 WPS, mandated that no worker could be present within the AEZ during any pesticide application. 4 aerial applications, which produce high drift conditions, the buffer zone was and remains 100 feet. The workers were not just within 100 feet of the application. They were the direct targets. The spray came down on them. This is not a borderline case. It is one of the clearest possible examples of an AEZ violation imaginable. The WPS also required that pesticide application handlers temporarily suspend spraying if workers or other people were present in the AEZ. There was no suspension. The application continued. And when it happened again 2 weeks later, twice in 30 minutes, the systemic nature of the failure became impossible to ignore. This was not an accident. This was a pattern. The lawsuit named the employer Pioneer, whose parent company is Corteva Agriscience, as well as the commercial applicator, Farm Air Incorporated. Corteva disputed the allegations publicly and stated its intention to defend vigorously. But the legal claim was grounded in specific regulatory violations: failure to maintain the AEZ, failure to halt application when workers were present, and the resulting physical harm to a group of people who had no way to protect themselves because no one had told them what was coming. This case also illuminates a deeper structural problem in how pesticide exposure is tracked and regulated in the United States. Certain states, California and Iowa among them, maintain systems to track pesticide exposure incidents. Illinois, where this incident occurred, had no such tracking system at the time. That means an unknown number of similar incidents may have occurred in that state without any record, any investigation, or any legal consequence whatsoever. This is not a hypothetical concern. A 2024 advocacy report described the enforcement of pesticide safety regulations across the country as a system that lacks the capacity to effectively protect farm workers. The cooperative agreement structure between federal and state agencies, where the EPA delegates WPS enforcement to state-level agricultural agencies, creates enormous variation in how aggressively the rules are applied. In states with underfunded inspection programs, violations that should trigger immediate enforcement action go undetected. In states with language access barriers, workers who experience poisoning never file a complaint because they don't know they have the legal right to do so or they fear retaliation. And the fear of retaliation is real. The WPS explicitly prohibits employers from retaliating against any worker who reports unsafe conditions or requests pesticide safety information. But a prohibition in regulation means little when the worker has no other income, lives in employer-provided housing, and comes from a community with deep historical reasons to distrust government institutions. The 2024 WPS updates restored the anti-retaliation provisions to their 2015 strength, but enforcement requires reporting, and reporting requires trust that the system will respond. The DeWitt County case is not an outlier. It is a window. And what it shows us is that the existence of the law and the lived experience of agricultural workers in America can occupy entirely different worlds. Understanding the rules is the beginning. But understanding why those rules aren't working, and what it would take to actually protect people, requires looking at the system as a whole. Let's start with the most fundamental tension in the current framework. The WPS is enforced not by OSHA, the federal agency responsible for workplace safety for virtually every other American worker, but primarily by the EPA through delegated authority to state agricultural agencies. This means that farm workers occupy a unique and historically disadvantaged position in U.S. labor law. They are covered by a specialized standard that was only created in 1992, decades after OSHA was established, and they are subject to an enforcement structure that varies dramatically from state to state. In California, the Department of Pesticide Regulation maintains one of the most comprehensive pesticide tracking systems in the country. Incident reports are collected, analyzed, and published. Fines are levied. But even California, the state with arguably the strongest pesticide regulatory infrastructure in the United States, has faced lawsuits over approvals of toxic fumigants near schools in Monterey County, where children were documented to be breathing chemicals at levels more than twice what the Office of Environmental Health Hazard Assessment considers safe. The strongest state system in the country is still not strong enough in every case. In other states, the gap is far wider. The lack of consistent data collection across states means that the true scale of pesticide poisoning in American agriculture is essentially unknown. Incident reports are only filed when workers know they have been exposed, know their rights, feel safe reporting, and have access to systems that will record their complaint. Each one of those conditions is routinely absent. So what would actually change things? Advocates and researchers who have studied this issue most closely point to several reforms. The first is extending full OSHA jurisdiction to agricultural workers, ending the historical carve-out that has kept farm workers in a separate and lesser protected legal category for 50 years. The second is mandatory uniform pesticide exposure tracking in all 50 states, so that the true scope of the problem becomes visible. The third is dramatically increased funding for WPS inspections and enforcement, because a standard that exists on paper but is never checked in the field is not really a standard at all. But there is also something that does not require legislation, does not require funding battles, and does not require years of policy advocacy. It requires knowledge. And that is why this video matters. If you are an agricultural employer, here is what the law requires of you right now. You must provide annual pesticide safety training to every worker and handler before they are exposed and every year thereafter. You must enforce restricted entry intervals and never allow workers to enter treated areas before the posted time. You must maintain the application exclusion zone during all outdoor applications and immediately halt spraying if anyone enters that zone. You must provide all required personal protective equipment at no cost, ensure it fits properly, ensure respirator users receive medical evaluations and annual fit tests per 29 CFR 1910. 134, and ensure contaminated PP never leaves the worksite. You must provide decontamination stations with clean water, soap, and single-use towels within reach of every working area throughout every shift. You must post pesticide application records in a central location accessible to all workers during work hours. And you must never retaliate against any worker who asks questions, requests information, or reports a concern. These are not things you can ignore because your operation is small, because you are in a state with weak enforcement, or because none of your workers have complained. Ignorance of the standard is not a legal defense, and the harm it allows is not abstract. It is happening right now in fields across this country. If you are an agricultural worker, or if you know someone who is, here is what you need to know. You have the legal right to receive pesticide safety training before you work near or with pesticides. You have the right to access records of what pesticides were applied, when, and where. You have the right to personal protective equipment without paying for it. You have the right to clean water and soap to wash off any chemical contact. You have the right to be kept away from treated areas during restricted entry intervals. You have the right to information about any pesticide that could have affected your health. And you have the right to report unsafe conditions without being fired, threatened, or punished. If any of these rights are being violated, you can report it to your state agricultural agency or directly to the EPA. And you can seek legal assistance through farm worker advocacy organizations such as Farm Worker Justice, Legal Aid Chicago, Earth Justice, and California Rural Legal Assistance. The fight over these protections is also playing out right now in the United States Supreme Court. In April 2026, the court heard oral arguments in Monsanto v. Durnall, A case centered on whether companies like Bayer can be held liable under state law for failing to warn consumers and workers about the cancer risks associated with their products, specifically glyphosate-based Roundup. The outcome of that case will determine whether state courts remain a viable avenue for people harmed by pesticides to seek compensation, or whether EPA label approval can function as a blanket shield against liability, even when companies may have concealed evidence of harm. Earthjustice, farm worker organizations, and former EPA officials have all filed legal briefs supporting the plaintiff. The stakes could not be higher, because if the court rules in favor of the chemical industry, the most powerful tool remaining for individual accountability, state court litigation, could be effectively eliminated. The people who feed this country deserve to go home from work without burning eyes, without vomiting, without wondering if the chemical they breathe today will show up in their body as cancer years from now. The rules to protect them already exist. What is still missing in too many places is the will to enforce them, and the knowledge among those most affected that those rules belong to them. Now you know what the law says. Now you know what happened in a cornfield in Illinois in 2019. Now you know the names: the Worker Protection Standard, 40 CFR Part 170, the Application Exclusion Zone, the Restricted Entry Interval, OSHA 29 CFR 1910, 1200, OSHA 29 CFR 1910, 134. These are not bureaucratic acronyms. They are the language of protection, and knowing them is the first step toward demanding that they mean something. Share this video. Send it to someone who works in agriculture. Send it to a farm owner. Send it to a public health professional. The more people who know what the law actually requires, the harder it becomes to pretend that no one knew, and the closer we get to a world where the rules on paper match the reality in the field.